Shares and capital. 1. Capital. The capital of a company means the amount of money that it is authorized by its memorandum to raise, generally by the issue of shares. Hence, a company's capital is also called share capital. Sometimes the phrase debenture capital is used to denote the amount borrowed by the company and secured by debentures. In company law, the word capital is used to mean the following. I. Nominal or authorized share capital. Nominal capital or authorized capital is the total face value of the shares which the company is authorized to issue by its memorandum of association. The total share capital of the company is also called its registered capital. 2. Issued share capital. Issued capital is that part of authorized capital which is actually offered to the public for sale. 3. Subscribed share capital. Subscribed capital is that part of the issued capital which is taken up and accepted by the public. 4. Paid up capital. Paid up capital is the amount of money actually paid by the subscribers or credited as so paid. V. Reserve capital. A company by a special resolution may declare that the uncalled capital of the company shall not be capable of being called up except when the company is wound up. This uncalled capital becomes the reserve capital of the company, Sector 74. 2. Classification of shares. The share capital of a company is generally divided into the following classes of shares. I. Preference shares. Preference shares are those shares whose holders are entitled to a fixed rate of dividend, before any dividend is paid to the ordinary shares. Preference shares might be cumulative or non-cumulative. In the case of cumulative preference shares, if the profit made by a company in a particular year is not sufficient to pay dividend at the prescribed rate, the shortage must be made up of the profits of succeeding year. In non-cumulative preference shares, such shortages are not required to be made up. Dividends which are not paid do not accumulate but lapses. 2. Ordinary shares. Ordinary shares are those whose holders are entitled to dividend out of the net profits of the company after the fixed dividend on preference shares has been paid up. 3. Deferred shares or founders' shares. Deferred shares or founders' shares are usually allotted to the promoters in consideration of the services rendered by them, and to the underwriters in consideration of the commission due to them. In either case, the particulars of contact must be filed with registrar and the number of such shares must be stated in the prospectus or in the statement in lieu of prospectus, Sector 135. The deferred shareholders are usually entitled to a certain proportion of the profits which remain after paying the dividend on the capital paid up on all the other shares for the time being issued at a particular rate. 3. Redeemable preference shares. Redeemable shares are those which are purchased back by the company subject to the conditions laid down in the Articles and in the Act. Section 154 of the Act provides that a company limited by shares may, if so authorized by the Articles, issue preference shares which are, or at the option of the company are to be liable to be redeemed. This section specifies the following rules relating to redemption. A. Such shares shall not be redeemed except put of profits of the company which would otherwise be available for dividend or out of the proceeds of a fresh issue of shares made for the purposes of the redemption. B. Such shares shall be redeemed unless they are fully paid. C. Where any such shares are redeemed otherwise than out of the proceeds of fresh issues, they shall be transferred to a reserve fund, to be called the Capital Redemption Reserve Fund, a sum equal to the amount applied in redeeming the shares. D. Where any such shares are redeemed out of the proceeds of a fresh issue, the premium, if payable on redemption, must be provided for out of the profits of the company before the shares are redeemed. Subject to the aforesaid rules, the redemption of preference shares may be effected on such terms and in such manner as may be provided by the Articles of the company. If a company defaults in complying with any of the provisions of this section, the company and also every officer of the company who is in default shall be liable to a fine not exceeding 2,000 taka. 4. Stock. When all the shares of a company have been fully paid, They may be converted into stock in a general meeting if so authorized by the Articles Sector 53, 1, plus. The use of the term stock merely denotes that the company have recognized the fact of the complete payment of the shares, and that the time has come when these shares may be assigned in fragments, which for obvious reasons could not be permitted before per Lord Cairns in Morris vs. Aylmer. Conversion into stock is made because it is a convenient method of denoting the capital of the company and the interest if the members. It does not affect the rights of the members in any way. When shares are converted into stock, notice must be given to the registrar. The register of members must thereafter show the amount of stock held by each member instead of the amount of shares, Sector 55. 5. Minimum subscription. Where shares are offered to the public for subscription, the prospectus must mention the minimum amount which must be raised by the issue of shares before the company can commence business. The minimum subscription is to be fixed by the directors or by the persons who have signed the memorandum. Section 148, 2, states that no allotment shall be made of any capital of a company offered to the public for subscription, unless the amount stated in the prospectus as the minimum amount is raised by the issue of these shares and at least 5% of that amount have been paid in cash to the company. This amount is to be determined by taking into account the flowing expenses. I. The purchase price of any necessary property. 2. The preliminary expenses, including commissions payable for the sale of shares. 3. Repayment of any money borrowed by the company for the above two purposes. 4. Working capital. The amount of minimum subscription stated in the prospectus shall be reckoned exclusively of any amount payable otherwise than in cash. All monies received from applicants for shares shall be deposited and kept in a scheduled bank until the certificate to commence business is obtained. A company can alter its share capital in a manner mentioned in its articles. However, if no such power is provided in the article, they may alter the article by a special resolution so as to provide for such power. The capital may be altered so as to increase, consolidate, cancel, or convert the shares, Sector 53. I. Increase of capital. The share capital of a company, whether converted into stock or not, may be increased in a general meeting by issuing new shares, Sector 53. Where the capital is increased beyond the registered capital, the notice of increase, including the particulars of the classes of shares affected, must be filed with the registrar within 15 days of the passing of the resolution. Increasing share by issuing new shares, according to Section 155, where the directors decide to increase the subscribed capital of the company by issue of further shares within the limit of the authorized capital, the following procedure are to followed. A. Such further shares shall be offered to the existing equity shareholders in proportion as nearly as circumstances admit. B. Such offer shall be made by notice specifying the number of shares offered and specifying the time limit, not being less than 15 days from the date of the offer, within which the offer, if not accepted, will be deemed to have been declined. C. After the expiry of the time specified in the notice aforesaid, or on receipt of earlier intimation from the members to whom such notice is given that he declines to accept the shares offered, the directors may dispose of the same in such manner as they may think most beneficial to the company. 2. Consolidation. If the articles provide, the company may in a general meeting consolidate and divide all or any of its share capital into shares of a larger amount than the existing shares, or convert all or any of the paid-up shares into stock and reconvert into paid-up shares of any denomination, Sector 53, 1b, c. Notice of consolidation, conversion or reconversion is to be filed within 15 days thereof with the registrar, Sector 54, 1. In default, the company and its officers are liable to a fine extending to Tk 200 per day, Sector 54, 2. 3. Subdivision. A company, if authorized by its articles, may subdivide in general meeting the capital into shares of a smaller amount than is specified in the memorandum. The effect of such subdivision will be that the remaining unpaid amount on each new share shall be proportionate to that unpaid on the shares from which the division made. Sector 53, 1d. 4. Cancellation. A company may cancel any share which at the date of exercising the power in that behalf have not been subscribed for or agreed to be subscribed for by any person, and diminish the amount of its share capital by the amount of the shares so cancelled. Sector 53, 1e. Restriction on purchase by company or loans by company for purchase of its own shares. Section 58, 1, of the Companies Act, 1994. No company limited by shares shall have power to buy its own shares or the shares of a public company of which it is a subsidiary company, unless the consequent reduction of capital is effected and sanctioned in the manner provided by Sections 59 to 70. Section 58, 2, of the Companies Act, 1994. No company limited by shares other than private company or a subsidiary company of a public company shall give, whether directly or indirectly, and whether by means of a loan, guarantee, the provision of security or otherwise any financial assistance for the purpose of or in connection with a purchase made or to be made by any person of any shares in the company. Provided that nothing in this section shall, where the lending of money is part of the ordinary business of a company, be taken to prohibit the lending of money by the company in the ordinary course of its business. Section 58, 3, of the Companies Act, 1994. If a company acts in contravention of this section, the company, and every offer of the company who is knowingly and willfully in default shall be liable to a fine not exceeding 5,000 taka. Section 58, 4, of the Companies Act, 1994. Nothing in this section shall affect the right of a company to redeem any shares issued under Section 154. Reduction of share capital. Section 59, 1, of the Companies Act, 1994. Subject to confirmation by the court, a company limited by shares, if so authorized by its articles, may by special resolution reduce its share capital in any way, and in particular the company may, as part of this general power, a. Extinguish or reduce the liability on any of its shares in respect of share capital not paid up. B. Either with or without extinguishing or reducing liability on any of its shares, cancel any paid-up share capital which is lost or presented by available assets. C. Either with or without extinguishing or reducing liability on any of its shares, pay off any paid-up share capital which is in excess of the wants of the company. D. So far as is necessary, alter its memorandum by reducing the amount of its share capital and of its shares accordingly. Section 59, 2, of the Companies Act, 1994. A special resolution under this section is in this Act called a resolution or reducing share capital. Section 60 of the Companies Act, 1994. Where a company has passed a resolution for reducing share capital, it shall apply by petition to the court for an order confirming the reduction. Section 60 of the Companies Act, 1994. On and from the passing by a company of a resolution for reducing share capital, or where the reduction does not involve either the diminution of any liability in respect of unpaid share capital or the payment to any shareholder of any paid-up share capital, then on and from the making of the order by the court confirming by the reduction the company shall add to its name, until such date as the court may fix, the words "and reduced" as the last words in its name, and those words shall until that date be deemed to be part of the name of the company. Provided that where the reduction does not involve either the diminution of any liability in respect of unpaid share capital or the payment to any shareholder of any paid-up share capital, the court may, if it thinks expedient, dispense altogether with the addition or words "and reduced." Reduction of capital is possible only by passing a special resolution and confirmation by the court. The court would inquire into the objections, if any, raised by the creditors. In this respect, the court settles the list of creditors entitled to object and issues public notices under Section 62. On hearing the objections, the court may confirm the reduction on such terms and conditions as it may deem fit. Sector 64. A limited company may by special resolution determine that any portion of its share capital which has not been already called up shall not be called up, except in the event and for the purposes of the company being wound up, and thereupon that portion of its share capital shall not be capable of being called up except in the event and for the purposes aforesaid, and such portion shall be called reserved share capital, Section 74. 9. Unlimited company to provide for reserve share capital on re-registration. When an unlimited company having a share capital adopts a resolution for registration as a limited company, can increase the nominal amount of its share capital by increasing the nominal amount of each of its shares, but subject to the condition that no part of the amount by which its capital is so increased shall be called up except in the event of the company being wound up. The portion of the share capital increased shall be called the reserved share capital, Section 73. 10. Transfer of shares. As per Section 30(1) of the Companies Act, 1994, the shares and other interest of any member in a company shall be deemed to be movable property and shall be transferable in the manner provided by the Articles of the Company. As per Regulation 18 of Schedule I of the Companies Act, 1994, the instrument of transfer of any share in the company shall be executed both by the transferor and transferee, and the transferor shall be deemed to remain holder of the share until the name of the transferee is entered in the Register of Members in respect thereof. Shares in the company shall be transferred following form prescribed in Regulation 19 of Schedule I of the Companies Act, 1994. Regulation 20 of Schedule I of the Companies Act, 1994 states the followings. I. The directors may decline to register any transfer of shares, not being fully paid shares, to a person of whom they do not approve, and may also decline to register any transfer of shares on which the company has lien. 2. The directors may also suspend the registration of transfers during the 21 days immediately preceding the ordinary general meeting in each year. 3. The directors may decline to recognize any instrument of transfer or refuse to register such transfer unless a fee not exceeding Taka 10 as may be fixed by the company is paid to the company in respect thereof. B. The instrument of transfer is accompanied by the certificate of the shares to which it relates, and C. Such evidence as the directors may reasonably require to show the right of the transferor to make the transfer. 4. If the directors refuse to register or decline to recognize the transfer of any shares, they shall, within 2 months after the date on which the transfer was lodged with the company, send to the transferee and the transferor notice of the refusal or decline. Regulation 21 of Schedule I of the Companies Act, 1994 states the followings. The executors or administrators of a deceased sole holder of a share shall be the only person recognized by the company as having any title to the share. In the case of a share registered in the names of 2 or more holders, the survivors or survivor or the executors or administrators or the deceased survivor shall be the only person recognized by the company as having any title to the share. Regulation 22 of Schedule I of the Companies Act, 1994 states the followings. I. Any person becoming entitled to a share in consequence of the death or insolvency of a member shall, upon such evidence being produced as may from time to time be required by the directors, have the right, either to be registered as a member in respect of the share or to make such transfer of the share as the deceased or insolvent person could have made. 2. Notwithstanding the provisions of Subregulation 1, the directors shall have the same right to decline or recognize the transfer or to refuse or suspense the registration of the transfer as they could have done under Regulation 20, had the transfer been made by the deceased or insolvent shareholder before his death or insolvency. A person becoming entitled to a share by reason of the death or insolvency of the holder shall be entitled to the same dividends and other advantages to which he would be entitled if he were the registered holder of the share, except that he shall not, before being registered as a member in respect of the share, be entitled in respect of it exercise any right conferred by membership in relation to meetings of the company. Section 38(1) of the Companies Act, 1994. An application for the registration of the transfer of shares in a company may be made either by the transferor or the transferee, Provided where such application is made by the transferor, no registration shall in case of partly paid shares be effected unless the company gives notice of the application to the transferee and subject to the provisions of subsection 7. The company shall, unless objection is made by the transferee 2 weeks from the date of receipt of the notice, enter in its register of members the name of the transferee in the same manner and subject to the same conditions as if the application for registration was made by the transferee. Section 38, 2, of the Companies Act, 1994, for the purpose of subsection 1, notice to the transferee shall be deemed to have been duly given if dispatched by prepaid post to the transferee at the address given in the instrument of transfer and shall be deemed to have been delivered in the ordinary course of post. Section 38, 3, of the Companies Act, 1994. It shall not be lawful for the company to register a transfer of share in or debentures of the company unless the proper instrument of transfer duly stamped and executed by the transferor and the transferee has been delivered to the company, along with script. Provided that, where it is proved to the satisfaction of the directors of the company that an instrument of transfer signed by the transferor and transferee has been lost, the company may, if the directors think fit, on an application in writing made by the transferee and bearing the stamp required by an instrument of transfer, register the transfer on such terms as to indemnity as the directors may think fit. Following new clauses have been inserted by the amendment dated September 7, 2020. 38. 3a. The signature of the transferee of the share in the deed of transfer of shares shall be endorsed as follows, namely: A. After submitting the list of directors concerned, annual capital statement, share transfer deed and affidavit in favor of share transfer to the registrar's office, the transferor concerned shall be present in person and confirm the authenticity of the share transfer by resignature. B. If the transferor of shares is a foreign national or resides abroad, the share transfer deed and affidavit in support of the transfer of shares shall be sent certified by the authorized officer of the concerned embassy, and C. If the transferee of the shares fails to appear at the registrar's office for reasonable grounds, a commission shall be sent by the registrar subject to the prescribed fee. Section 38, 4, of the Companies Act, 1994. If a company refuses to register the transfer of any shares or debentures, the company shall, within 1 month from the date on which the instrument of transfer was lodged with the company, send to the transferee and the transferor notice of the refusal. Section 38, 5, of the Companies Act, 1994. If default is made in complying with subsection 4 of this section, the company shall be liable to a fine not exceeding 100 taka for every day during which the default continues, and every director, manager, secretary, other officer who is knowing by a party to the default shall be liable to a like penalty. Section 38, 6, of the Companies Act, 1994. Nothing in subsection 3 shall prejudice any power of the company to register as shareholder or debenture holder any person to whom the right to any shares in or debentures of the company has been transmitted by operation of law. Section 38, 7, of the Companies Act, 1994. Nothing in this section shall prejudice any power of the company under its articles to refuse to register the transfer of any shares. Certification of transfer. Section 39, 1, of the Companies Act, 1994. The certification by a company of any instrument of transfer of shares in, or debentures of, the company, shall be taken as a representation by the company to any person acting on the faith of the certification that there have been produced to the company such documents as on the face of them show a prime facie title to the shares, or debentures in the transfer named in the instrument of transfer, but not as a representation that transferor has complete title to the shares or debentures. Section 39, 2, of the Companies Act, 1994, where any person acts on the faith of an erroneous certification made by a company negligently, the company shall be under the same liability to him as if the certification has been made fraudulently. Section 39, 3, of the Companies Act, 1994, for the purposes of this section. A. An instrument of transfer shall be deemed to be certificated if it bears the words certificate lodged or words to the like effect. B. The certification of an instrument of transfer shall be deemed to be made by a company if the person issuing the certificated instruments is a person authorized to issue such instruments of transfer on the company's behalf, and the certification is signed by any officer or servant of the company or any other person authorized to certificate transfers on the company's behalf, or if a body corporate has been so authorized by any officer or servant of that body corporate. C. A certification shall be deemed to be signed by any person if it purports to be authenticated by his signature, unless it is shown that the signature was placed there neither by himself nor by any person authorized to use the signature for the purpose of certificating transfers on the company's behalf. Regulation 7 of the First Schedule I of the Companies Act, 1994 states the following. If a share certificate is defaced, lost, or destroyed, it may be renewed on payment of such fees, if any, not exceeding 5 taka, and on such terms, if any, as to evidence and indemnity as the directors think fit. Transfer of shares by legal representative. Section 40 of the Companies Act, 1994, a transfer of the share or other interest of a deceased member of a company made by his legal representative shall, although the legal representative is not himself a member, be as valid as if he had been a member at the time of the execution of the instrument of transfer. Application of premiums received on issue of shares. As per Section 57 of the Companies Act, 1994, application of premiums received on issues of shares will be as follows. Where a company issues shares at a premium, whether for cash or otherwise, a sum equal to the aggregate amount or value of the premiums on those shares shall be transferred to an account, to be called the share premium account, and the provisions of this act relating to the reduction of the share capital of a company shall, except as provided in this section, apply as if the share premium account were paid up share capital of the company. The share premium account may be applied by the company. A. In paying up unissued shares of the company to be issued to member of the company as fully paid bonus shares. B. In writing of the preliminary expenses of the company. C. In writing off the expenses of, or the commission paid or discount allowed, on any issue of shares or debentures of the company, or D. In providing for the premium payable on the redemption of any redeemable preference shares or of any debentures of the company. Where a company has, before the commencement of this act, issued any shares at a premium, this section shall apply as if the shares had been issued after the commencement of this act, provided that any part of the premium which has been so applied that it does not at the commencement of this act form an identifiable part of the company's reserves within the meaning of Schedule 11 shall be disregarded in determining the sum to be included in the share premium account.